Hey guys, SHOT Show 2025 is here, and because of that, you're going to see a little bit of an influx here on the channel. We're going to try to interview as many influential people in the Second Amendment space, as well as manufacturers that we possibly can, so that you can have information on who's contributing here in the Second Amendment advocacy world. So gear up. We're probably going to be getting out about a video a day as we go through these interviews, so be sure to look out for that in the upcoming couple weeks. Hey everybody, welcome back to the channel today. That is right, we've got more litigation to cover, some big lawsuits in California. Really want to see what is going to be encompassed in 2025. We don't normally get to see him in person, but today we do. To talk us through that today is Chuck Michel. Chuck, how are you today?
All right, good to be here at SHOT, hanging out with you fellas.
Absolutely. And guys, before we get into this today, please be sure to like, share, and subscribe to these videos. Really helps get this information out to as many people as possible. At the end of the day, we're looking to educate on Second Amendment litigation, legislation, and cultural movements throughout the state of California. And of course, Chuck, I guess before we jump into it today, you got your sporting your CRPA 150th anniversary shirt.
It's the 150th anniversary. Visit the CRPA store. There's all kind of swag. You get one of these great polos. We've got challenge coins for sale, and also I think these are going to be a promo if you make a certain amount of donation. And we have the new edition of the California Gun Laws book, which one of these days hopefully will be down to a brochure once we get most of these repealed and struck down. But in the meantime, if you own this book, it'll help you stay out of jail, not become an accidental criminal because of how complicated California's gun laws are.
Definitely coveted by a lot of people, and something that is of continued interest, at least what I've seen throughout the year. So thank you very much for producing that. We're definitely happy to get that to as many people as possible. You know, Chuck, I guess before we jump into a couple of these lawsuits that I want to talk to you about, going back to last year, you ended up speaking at the Gun Rights Policy Conference down there, and I think it was San Diego. You kind of summed up the evolution of Second Amendment law before, and I just kind of was sitting there in the crowd thinking to myself, holy smokes, that we should try to get this on the channel. I'm just sort of curious if you can go over that again. You know, you've been in this game a long time. You've litigated a lot of cases, challenged a lot of different laws, especially in the state of California, helped out elsewhere in the United States. Can you just sort of summarize that and summarize the evolution of Second Amendment law in the United States?
Well, the evolution of Second Amendment law is really driven by the evolution of gun control laws. And in California and New York, back in 1923, I think, is when the war against carrying firearms in public really started. That was the Sullivan Law in New York State, and California adopted its concealed carry ban, and you could get a CCW, a permit to carry a concealed weapon, or a license to carry. And the abuse of that was, they said that if you had good cause, you could get that license. But that evolved over the years into a more and harder to get that license to carry, and more places where guns were banned. And so they first went after public carry, then they went after types of people that they wanted to ban, and then places where they would be banned, and then types of firearms that would be banned. So that evolved into, in 1989, the California so-called Assault Weapon Control Act, which has been expanded and expanded every year. They just redefine. That's what's so great about that law for a gun ban lobby. They just redefine the term assault weapon and make it broader and broader and broader to cover more and more firearms. But in response to those, since the 70s, the NRA board voted to try and get a Second Amendment case back to the United States Supreme Court. And for years, the Supreme Court wasn't taking those cases because, remember, it takes 4 votes to take a case, 5 votes to win one. We had 4 votes to take the case, but we didn't have that 5th vote. So a lot of our friends were voting against taking Second Amendment cases. Finally, that changed in 2008 with the Heller case, because the composition of the court at that time, which, by the way, changed. And if it hadn't changed while Heller was pending, we could very well have lost that case. But that finally said, the fight always was whether or not the Second Amendment protected a collective right of the states to form a militia, or an individual right of individual citizens to keep and bear arms. And finally, that debate was settled in the Heller case in 2008, and then the McDonald case applied the Heller case to applied the Second Amendment rights to state and local governments, so they couldn't infringe on it either, because Heller was brought against the District of Columbia, which is a federal enclave. So it didn't affect state or local government's ability to restrict guns until McDonald came along. But then the big one that we got after a per curiam opinion in Castello against tear gas law in Massachusetts was Bruin. And that case that challenged New York's law banning, requiring you to have a special need to get a permit to carry carry a firearm in public. And so that law was struck down, and that wiped out all the good cause requirements that had been put in place in states across the country, including, unfortunately, California. And that's why California is now loosened up, and it's possible to get a CCW, and that's one of CRPA's biggest projects right now, is the CCW Reckoning Project, where we're going jurisdiction by jurisdiction, forcing them to, first of all, issue, and second of all, issue in a timely way, and third of all, in a way that's not cost prohibitive for most folks. So those are still battles that have to be fought every day, and by jurisdiction to try and get these permits down to be affordable. But we've had some great luck in some of those cases. Non-resident permits are going to start to be issued, and we're still litigating some other issues in those cases. But that's kind of it in a nutshell. But it comes down to the gun ban lobby, and that's what it is. It's about civilian disarmament. Goes after certain types of firearms, and the more they can get, the better. Certain type of people, and the more people they can ban, the better. Certain places, and the more places they can ban firearms, the better for them. From their perspective. So ultimately, they want to red tape gun rights to death and make them so limited that they're effectively not useful for using a firearm for self-defense.
And it seems like, as those things happen at the state level, when they become bigger issues at the federal level, we do end up getting decisions from the Supreme Court that continue to solidify our Second Amendment rights. We saw that with Heller, McDonald, and then Bruin.
And we have several pending there now that we
have several.
Very hopeful. In fact, there'll be a conference on Friday, the 24th of January, which we'll probably hear of from them on Monday about whether they've taken those cases or not.
And we'll definitely be looking forward to those cases. But let's draw it back to other recent events here. We do have the May v. Bonta case that we've been challenging at the Ninth Circuit now, and we appealed it to the En Banc panel, and they ended up denying the hearing. When we normally do a video on something like that, it's because there's oral arguments, or there's an opinion, or there's a judgment somewhere. So this may not have been headline news that people are seeing across the Second Amendment movement in California, but there was a challenge there, and the hearing was denied. So I'm just sort of curious, what are your thoughts on that? Why would the En Banc panel, that is so used to taking Second Amendment cases, deny hearing on that? And does that mean that May v. Bonta goes upward or downward?
Well, that's a good question. Remember, there are three cases involving prohibited places, gun-free zones. And remember, it's not actually a gun-free zone. I need to be careful about how I describe this. The laws in California, if you don't have a CCW, regulate the way you can carry guns in certain areas. Some areas guns are completely prohibited. Other areas, they're not. They have to be carried unconcealed, unloaded, in a locked container, whatever the rules are. Look it up in the book and get the details. But if you have a CCW, what that enabled you to do was carry concealed and loaded in most of those places. Now, the state, and it's important to remember, for 123 years, you had since 1923 or more, you had these laws that allowed you to carry in all these places as long as you had a CCW. And people who got these licenses were vetted, and they still are. There's a background check done on these folks. And they're among the most law-abiding citizens out there, are licensed carriers. But the state didn't want, once Bruin came down and people started to be able to get CCWs, the state, and led by Gavin Newsom, wanted to make those CCWs as useless as possible. So they made them as hard to get, as expensive to get, and then they tried to make them invalid in as many areas as they could. even though there'd never been a problem with people with CCWs in any of those areas that they then now deemed to be sensitive, because in Bruin, the Supreme Court did say that you could ban guns in sensitive areas. So the fight is over what is in fact a sensitive place where CCWs can be invalidated. And so, in fact, CRPA put out a memo. We'll be putting out another one, sort of a practical guide to how to comply with this current state of the law, what areas the sensitive places doctrine was deemed to be a valid exercise of state rights and where they weren't. But now procedurally, to get to that part of your question, we could take this up to the United States Supreme Court, but the Supreme Court has definitely made it clear that they are not inclined to accept cases that are up on an interlocutory appeal. That means an appeal from a preliminary injunction hearing as opposed to appeal from a final judgment. So I think we're inclined to go back down to the trial court, continue to litigate the issues there, get a final judgment there, and then take it to the United States Supreme Court when we're much more likely to be accepted. Now, in the meantime, there are other cases, sensitive places cases. Remember I said they're going after as many people as they can, as many places as they can, and many types of guns as they can. So the sensitive places cases are some of those prohibited places cases that are going on across the country. And the one out of New York is particularly promising, perhaps, even though it's, I believe, still an appeal from an injunction request that's now in front of the Supreme Court. So all we need, that's the thing people need to keep in mind. One case from any state can affect the law in all the states, and that definitely includes primarily California because it's one of the primary battleground states along with Illinois and New York, New Jersey, some others. But so that now the Wolford case, which is the Hawaii sensitive places case, that case is more problematic because the court upheld the so-called vampire rule, which says in order to take a gun onto private property, there has to be a sign posted that says guns are allowed, rather than a sign posted that's in places where a private property doesn't want you to bring a gun that says guns prohibited. And the politicians know that most people are not going to go out of their way to post a sign that says guns allowed. So de facto, they will get a lot of private properties where guns are not prohibited because there's no sign. Well, there's a split of opinion among the circuits on that particular question. And so Wolford will probably ask the Supreme Court to review that split of opinion before it goes back down in Hawaii. But the two California cases, the CRPA's May case and the Caballeros case, will probably go back down to the trial court and be litigated there through judgment.
And I guess, we continue to impress this, and I think it's really important, so I'm glad that we do. But going back down to get that final judgment, is the one step back that you need to take in order to take two steps forward. The threshold, it seems like, that the Supreme Court is creating is that final judgment. So if all that we're asking for is a preliminary injunction, we can't necessarily appeal that to the Supreme Court because they're not going to take it. They require that judgment.
Right, and in fact, our strategy before was to try and get the ruling on the preliminary judgment as quickly as possible, preliminary injunction as quickly as possible. And now we're looking at ways to get a judgment faster. We may bypass, in some cases, even requesting a preliminary injunction, just go straight for a permanent injunction and a motion for summary judgment so that we get that judgment locked in, because the Supreme Court is looking for a record. And this is what CRPA was doing in Illinois and in some of our cases in California, where you have to go and you have to put evidence in and expert declarations and testimony. That's all the factual development that goes on in a trial that results in a judgment based on those facts, as opposed to a preliminary injunction, which is often just based on, the reading of the law and not necessarily a whole lot of testimony or expert opinion or whatever. So it's a little more preliminary, which is why it's called a preliminary injunction, than a permanent injunction and judgment. So the Supreme Court likes to see that underlying court record, fully developed so that there's no open questions. They don't want to take a case and waste their time when some procedural issue pops up that they didn't anticipate. It distracts them from like when New York repealed its concealed carry
laws before it could get into
Yeah, because they want to moot the case.
Yeah.
So the court doesn't want to have an argument about mootness. They want to have an argument about the Second Amendment.
Right. And that, hey, you know what? That's fair enough. I guess, while it creates a little bit more work up front and perhaps stretches the timeline of where you would want it, it does create seemingly a more permanent solution for the years to come. So, and as we continue to look for ways to get those judgments faster, I'm sure that process speeds up and still gets us the result that we want. I'm also sort of curious, being at SHOT Show, we have the opportunity to talk to some manufacturers. We've got some new firearms coming onto the handgun roster in California from some smaller manufacturers, primarily out of Texas and a couple other of those southern states. What is the status with the Boland decision? And I'm curious what you see for the Boland, because I think the Boland decision, or at least the Boland case, was the only case that the Ninth Circuit panel actually came out and said, we're literally staying this until we hear from Duncan. They were the only panel that actually came out and said that they were doing that. So I guess this is connected to Duncan in a way. I guess just final thoughts for 2025. How do you see the progression there? Because we still have two things that we're challenging on that roster in the Boland lawsuit.
Absolutely.
Do we see any progression there?
Well, there is still some work to do in the trial court, but essentially a number of cases. The Rhodey case, CRPA's Rhodey case, challenging the ammo background check requirement. The Rupp case challenging the semi-auto ban. There's a number of other cases that are all kind of bottlenecked behind Duncan. And Duncan may or may not be bottlenecked behind some case that the Supreme Court is going to take. So if they take Snopes, I wouldn't be surprised to see Duncan held until the Supreme Court rules on Snopes. So it's really all keyed to the Supreme Court setting the record straight on what the methodology is for evaluating a Second Amendment challenge, because even though to me it's clear as a bell in what they said in Bruin and even Rahimi, but some of the lower courts that are inclined to not like the Bruin decision, this lower court, the appellate court judges, are really bending over intellectually backwards to try and kind of twist that opinion and uphold what should be declared to be unconstitutional gun control laws. So the Supreme Court's really got to put its foot down and make it clear that they can't get away with those kinds of shenanigans, and that the test is, X, Y, Z, and you have to apply it, or
well, I certainly feel like the cultural movement is moving towards acceptance of something like that. We've got an administration that's very open to decisions like that, and we've got a Supreme Court that's kind of dialed in and very opportunistic in being able to do something like that. So, I mean, as always, it's a lot to look forward to. We've got a lot of opportunities.
It's going to be a busy year.
Court.
Going to be a busy year, and we have lots more cases to file too, especially on the CCWs where the jurisdictions are dragging their feet or charging too much. There's going to be individual battles in a lot of those jurisdictions, and they have to be fought. Every time you win one, it makes precedent for other jurisdictions. So that's probably going to be a large part of our fight. I think we're going to see some great stuff out of the Trump administration, and we're going to see the ATF have its wings clipped, which will be a good thing. But Cal DOJ is still right out there pushing the envelope, trying to restrict as much as they can. We have to fight them every day.
Oh, yeah.
So we really need everybody to join CRPA and support CRPA's efforts. And not just the lawsuits. We have a lot of great programs, which I'm sure folks know about, all the shooting programs and training programs and hunting and conservation programs, all the things CRPA does just really deserve support. We're doing far and away more work than we've ever done in the past in California, and we really need folks to get behind us in that.
Well, yeah, and really looking forward to following along with these lawsuits as they continue to make their way through, as well as, we'll have to have you back on as these other challenges, because there certainly is a lot of other challenges that are necessary just in the state of California to be filed. So look forward to following up with you on that one.
Absolutely.
But also, thanks for coming on. Thanks for spending the time. Always appreciate the knowledge.
Always a pleasure, guys. Appreciate having me.
Absolutely. And guys, if you like videos like this and you want to continue and see more, please, as always, be sure to like, share, and subscribe. to these videos. It really helps with the algorithm to push these videos as far out as they go. Again, at the end of the day, we're always looking to educate on Second Amendment litigation, legislative, and cultural efforts. Thanks again, guys, and we'll see you on the next one.